Welcome to Learn Short and Tapping with VIKAS Sir. Trial passage for Punjab and Haryana High Court and Chandigarh High Court. Exercise number 20 and 21. Advanced magazine at the rate 80 to 100 word per minute. Be ready? Start. Of course, the task of restructuring the social and economic order so that the social and economic right become a meaningful reality for the poor sections of the community is one which legitimately belongs to the legislature and the executive, but mere initiation of social and economic rescue programs by the executive and the legislature would not be enough, and it is only through multi-dimensional strategies including public interest litigation that these social and economic rescue programs can be made effective. Public interest litigation is essentially a cooperative or collaborative effort on the part of the petitioner, the state of public authority, and the court to secure observance of the constitutional or legal rights, benefits, and privileges conferred upon the vulnerable sections of the community and to reach social justice to them. The state or public authority against whom public interest litigation is brought should be as much interested in ensuring basic human rights, constitutional as well as legal, to those who are in a socially and economically disadvantaged position as the petitioner who brings the public interest litigation before the court. The state or public authority which is arrayed as a respondent in public interest litigation should in fact welcome it, as it would give it an opportunity to right a wrong or to redress an injustice done to the poor and weaker sections of the community whose welfare is and must be the prime concern of the statement of the public authority. The legal and monumental and public interest litigation seek to bring justice to these forgotten specimens of humanity who constitute the bulk of the citizens of India and who are really and truly the people of India who gave to themselves this magnificent constitution. Pendency of large areas in the courts cannot be any reason for denying access of justice to the poor and weaker sections of the community. The time has now come when the courts must become the courts for the poor and struggling masses of this country. They must shed their character as upholders of the established order and the status quo. They must be sensitized to the need of doing justice to the large masses of people to whom justice has been denied by a cruel and heartless society for generations. The realization must come to them that social justice is the signature tune of our Constitution, and it is their solemn duty under the Constitution to enforce the basic human rights. This new change has to come if the judicial system is to become an effective instrument of social justice, for without it, it cannot survive for long. Fortunately, this change is gradually taking place and public interest litigation is playing a large part in bringing about this change. It is through public interest litigation that the problems of the poor are now coming to the forefront and the entire theatre of the law is changing. It holds out great possibilities for the future. This writ petition is one such instance of public interest litigation. It is true that construction industry does not find a place on the schedule to the Employment of Children Act 1938 and the prohibition enacted in section 3 subsection of the act against the employment of a child who has not completed his 14-year cannot apply to employment in construction industry, but apart altogether from the requirement of Convention number 59 of C, the International Labour Organization, and ratified by India. Article 24 of the Constitution provides that no child below the age of 14 shall be employed to work in any factory or mine or engaged in any other hazardous employment. This is constitutional prohibition which, even if not followed up by appropriate legislation, must operate the construction work being plainly hazardous employment. It is clear that by reason of this constitutional prohibition, no child below the age of 14 years can be allowed to be engaged in construction work. Therefore, notwithstanding the absence of specification of construction industry in the schedule of the Employment of Children Act 1938, no child below the age of 14 years can be employed in construction work, and the Union of India, as also every state government, must ensure that this constitutional mandate is not violated in any part of the country. Magistrates and judges in the country must view violations of labor laws with stridence, and whenever any violations of labor laws are established before them, they should punish the errant employers by imposing adequate punishment. The labor laws are enacted for improving the conditions of workers, and the employers cannot be allowed to buy off immunity against violations of labor laws by paying a paltry fine which they would not mind paying, because by violating the labor laws they would be making profit while would far exceed the amount of the fine. Full stop.